Good day, everyone, especially to you, Mom. So, we are the Group 8, and we're going to tackle about Chapter 6, Other Education and Teacher-Related Laws. And by the way, this is Rhea Jamaica Esperisaurus, and I will be the first presenter from this group. Lesson 1, Republic Act 7877, an act declaring sexual harassment unlawful in the employment, education, or training environment, and for other purposes. So, first of all, what is sexual harassment? Sexual harassment is any unwelcome verbal, visual, or physical conduct of a sexual nature that is severe or pervasive and affects working conditions or creates a hostile work environment. So, it means nga kanang against nimo nga buhaton sa usa ka tawo nga bastusan ra ka in terms of verbal, visual, or physical. So, there are three forms of sexual harassment as I mentioned earlier. And first, we have the verbal harassment. It includes comments about clothing, a person's body, sexual or gender-based jokes or remarks, requesting sexual favors, or repeatedly asking a person out. It also includes sexual innuendos, threats, spreading rumors about a person's personal or sexual life, or using foul or obscene language. So, verbal harassment, makaingon ta na kay verbal in terms of pagstorya. So, sexual innuendos is that kanang musulti kag mga words nga tagaan og deeper meaning nga bastos. So, ma-appeal na siya sa sexual innuendos, which is one of the example of verbal harassment. Next is the visual harassment. Can include poster, drawings, or pictures, screensavers, cartoons, emails, or texts of a sexual nature. So, visual harassment, which is makita na to nga mga pictures o posters nga mga bastos or kanang mga bikini pictures and which is against sa katong tao nga nasa picture. So, pwede na siya makuanan og visual harassment. And then the third one is the physical harassment, often includes sexual assault, impeding or blocking movement, inappropriate touching such as kissing, hugging, patting, stroking, or rubbing, sexual gesture, even leering or staring. So, ang leering o staring ka, maapil na siya once ang usa ka tawo kay kanang lain ka siya tinutukan murag kuan kay tinutukan dili sa kanang naikalagot but murag kuan kay tinutukan niya bastusan kay tinutukan niya, so it all can be also included in physical harassment. The next, so the Republic Act of the Philippines made a law that can protect us from sexual harassment, and so this is the section titled, "This Act shall be known as the Anti-Sexual Harassment Act of 1995." So this law was made or was approved on February 14, 1995 and became effective on March 5, 1995. So, section number 2, Declaration of Policy. The state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants for employment, student or those undergoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. So, kani nga policy game mo ni siya kay para aksyonan to ang mga tao nga kanang mo violate na or mo matapakan na nila ang dignidad sa usa ka tao or ang human rights sa usa ka tao. And then the section number 3, work, education, or training related sexual harassment defined. Work, education, or training related sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person having authority, influence, or moral ascendancy over another in a work of training or education environment, demands, requests, or otherwise requires any sexual favor from other regardless of whether the demand, request for submission is accepted by the object of a said act. So, the anti-sexual harassment, masoda na siya ang kanang mo demand or mo request. So, basta ma-kuan siya sa mga sexual behaviors, something na. Masoda na siya sa law sa anti-sexual harassment. So, to So, para specific na to, and first kay in a work-related or employment environment, sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of a said individual, or in granting said individual favorable compensation, terms, condition, promotion, or privileges, or the refusal to grant the sexual favor result in limiting or segregating or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. So, in work-related, like, maayong siya nga, ma-appear siya sa sexual harassment once, sabi ka ng guwapa kay ka, and then, kanang nang-apply kag trabaho, nga nagwapahan ang imong na-applyan ang boss nga na-applyan nimo nga trabahoan. Then na siya condition nga iya kang I accept sa trabaho niya once buhaton na nimo something ana, which is kanang bastos. So pwede na siya makon sa sexual harassment towards nimo. And then next the above acts would impair the employee's rights or privileges under existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. So, makadaot siya sa employee. Ang nga ato nga mga mahitabo sa work. In education or training environment, sexual harassment is committed against one who is under the care, custody, or the supervision of the offender, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender, when the sexual favor is made condition to the giving of passing grade or the granting of honors and scholarships or the payment of the stipend allowance or other benefits, privileges, or considerations. So, in terms of education, kay nasay nana nga may tabo like sabi ang usa ka estudyante kay dili kay siya kamao, and then ang teacher or instructor kay mukha siya nga pabuhato na and in return kay tagaan siya passing grades something. So pwede makuha na siya sa sexual harassment. And then when the sexual advances result in intimidating, hostile, or offensive environment for the result trainee or apprentice, any person who directs or induces another to commit any act of sexual harassment as herein defined, or who cooperates in the commission thereof by another without which it would not have been committed, shall also be held liable under this act. So, kana sang situation nga ang tao wala siya gibuhat nga ini nga bastos, but naa siya gisugo nga usa ka tawo para buhaton or iyang i-push ang usa ka tawo nga buhaton na in term niya with return ana. So pwede na siya ma-appeal sa makasuhan sa na siya anti-harassment law in the Philippines. So
Section 4. Duty of the employer of head of office in a work-related, education, or training environment. First, it shall be the duty of the employer or the head of the work-related, educational, or training environment or institution to prevent or deter the commission of acts of sexual harassment and to provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. Towards this end, the employer or head of office shall A. Promulgate appropriate rules and regulations in consultation with the jointly approved by the employees or students or trainees through their duly designated representatives, prescribing the procedure for the investigation or sexual harassment cases and the administrative sanctions therefor. Next, administrative sanctions shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. The said rules and regulations issued pursuant to this section shall include, among others, guidelines on proper decorum in the workplace and educational or training institutions. B. Create a committee on decorum and investigation of cases on sexual harassment. The committee shall conduct meetings as the case may be with other officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of the alleged cases constituting sexual harassment. Next, in the case of a work-related environment, the committee shall be composed of at least one representative each from the management, the union, if any, the employees from the supervisory rank, and from the rank and file employees. In the case of educational or training institution, the committee shall be composed of at least one representative from the administration, the trainers, teachers, instructors, professors or coaches, and students or trainees as the case may be. And the last one, the employer or head of office, educational or training institution shall disseminate or post a copy of this act for the information of all concerned. So overall, in this section 4, it is stated that it is the duty of the work or of the head of the office to disseminate rules and regulations about sexual harassment. And Section 5, liability of the employer, head of office, educational or training institution. The employer of head of office, educational, training institution shall be solidarity liable for damage arising from the acts of sexual harassment committed in the employment, education, or training environment. If the employer or head of office, educational, or training institution is informed of such acts by the offended party and no immediate action is taken thereon. Section 6. Independent action for damages. Nothing in this act shall preclude the victim of work, education, or training-related sexual harassment from instituting a separate independent action for damages and other affirmative relief. So, in connection with Section 5 and Section 6, so if you are not satisfied of what is the result of your case, then if you believe that the person deserves more of what the case is, you can get your own lawyer, public or private lawyer, to handle the case, and of course with your knowledge and his expertise. So it's your right to get a public or private lawyer.
Section 7. The penalties. If any person who violates the provisions of this act shall upon conviction be penalized by imprisonment of not less than 1 month or more than 6 months, or a fine of not less than 10,000 pesos or more than 20,000 pesos, or both such fine and imprisonment at the discretion of the court. Any action arising from the violation of the provision of this act shall prescribe in 3 years. So, if the person who found guilty of sexual harassment will be penalized by imprisonment not less than 1 month or more than 6 months, or they will charge a fine of not less than 10,000 pesos or 20,000 pesos, or both, the person who found guilty of the sexual harassment will be imprisonment, or they will fine or charge at the discretion of the court. It means it depends on the decision of the judge. It depends on the decision of the judge upon a predefined legal guideline or a rule or policies. But what are the penalties for offenses of this sexual harassment? So first is we have 3 types of offenses. First is a grave offenses, or this dismissal. It means the person who found guilty will be quit voluntarily on his or her job. So this grave offenses is the unwanted touching of private parts of the body, like the buttocks or breast of the victim. or the requesting for a sexual favor in exchange for a passing grade, or granting of honors or scholarship. So that was the grave offenses. That's it. And the second one is the less grave offenses. This less grave offenses has two offense. First is the first offense. The fine or suspension for 30 days but not exceeding in 6 months. They will suspend at his or her job for 30 days or not exceeding by 6 months. Or the second offense is the dismissal. They will quit his or her job voluntarily, like what I said lately. So the less grave offenses is the verbal abuse or threats with sexual overtones. Like if the teacher will treats you with nga hagbungon ta ka kung if di ni mo ihata kung gusto, something like that. So the next one is the light offenses. The light offenses had three types of offense. The first offense is the reprimand. Reprimand is the criticism. Like for example, the student being the teacher is being told by a teacher I say up there, mo ni final example. The example of reprimand is the teacher is being told by a police officer that he is wrong, that what he did to his student. So, mo na example karon na. So, the next one is the next offense, second offense is the fine or suspension when not exceeding 30 days. So, just like I said lately, the second offense is the suspension or fine they will charge for 30 days. And the third offense is dismissal. It depends on them if they will quit to their job voluntarily or magsabot sila sa head of education. That's what. So, the next one, ang mga sala nga ilang nabuhat nga offense na light offenses is the stealing a look at the student or a person's private part or a word undergarments. Like kabantay man ta ng mga murag manyak-manyak naong kadang mutanaw sila sa parts sa atong body, sa private parts niya, kanang mga sarili na itong gagmay ilang tutukan kaayo. So that's the light offenses. Or sulti sila, uy, sexy, or mag-joke sila nga sexy ta, but mo rito na may pagnanasa na dito. So, what penalty shall be applied if the respondent is found guilty? So, it depends. The penalty to be imposed shall be corresponding to the most serious charges. It depends on kung unsa gid nga ang ilahang, kung seryoso ba gid or mas dako-dako ba ang ilang nabuhat nga sa, just like I said lately. If sila is nag-request lag for sexual favor, so na ang lang offense is grave offenses. So just like that. So the next one is the Section 8 separability clause. So if any person or provision of this act is declared void and unconstitutional, the remaining portions or provisions hereof shall not be affected by such declaration. So the damages that resulting from sexual harassment by that person who did may be separately and independently instituted. But in fact, if the employer or the person who did that sexual harassment or liable for the person who liable for the damages who arising from the acts of like sexual harassment that he or she committed, and if the head of educational institution is informed of such acts by the offended party and not immediate action is taken, like if separate na siya dapat ang nakabuhat ana nga sexual harassment, if kanang person say nakabuhat ana siya ray mapunish. But if the head of the education is kaybaw siya nga kana nahitabo na wala siya ni himog action, malabot na siya, like siya kuan pragkonsyaba siya sa person who committed that crime. The next one, section 9, repealing clause. All laws, decrees, orders, rules, and regulations, other insurances, or parts thereof inconsistent with the provisions of this act are hereby repealed or modified accordingly. From the word repealing, it means to revoke or mawalang bisa, or it will canceling the law. So it means that this section will mapawalang bisa if the CODI or the Committee in Decorum and Investigation, if they will accept the mga reklamo or mag-imbestiga sila balik o magsagawa ng mga hearing sa kasong sexual harassment. Maybe mausab ang ilahang decisions if mag-investigate sila balik or maminaw sila sa mga sulti sa mga tao, like of this sexual harassment. The next one is the section 10, effectivity clause. Effectivity clause. It means this act shall take effect 15 days after its complete publication in at least 2 national newspapers of general circulation. So the school institutions na sila 15 days para ilang i-arrange or tarungon ang case the sexual harassment before the submissions of CODI's report of the disciplinary authority, or before mo-complete ang publication into national newspaper. They have 15 days to arrange that sexual harassment nga nahitabo sa ilang institution. So that's it. That's it. Thank you for listening.